Good afternoon. I often say to Irene that one of my weaknesses is I forget companies do anything other than borrow. I suppose naturally, from my perspective, thinking about the implications for secured lending in the legislation. Irene has talked about the transition to reform. And in this area, the area we're going to be talking about now, I think we're very much seeing the recommendations of the Company Law Review Group being given effect. The result is you're dealing with something which isn't especially radical. There's very little radical. The question about Section 60, Section 31, they're slightly jigged around, but there's very little radical. And I would have to say that from a lending perspective, the improvements, or many of the improvements, are positive. They tidy up messinesses, and that's the aim. And I think that the Company Law Review Group has helped in giving us that kind of a grounding. I was surprised to see how many amendments were made at Janet stage. I really thought that coming out of the door we would sort of not see so much work still to be done, and I have a slight suspicion that Section 412, which is one of the sections that I'll be talking about in a bit, which was amended at Janet stage, I wouldn't be surprised if there's not a little bit more work to be done there. So what I'm going to be talking about is briefly about the implications for lenders of the removal of ultra vires. So I'll talk about that pretty briefly. I think Irene has covered that very extensively. I'm going to be talking about the old Section 60, the assistance in financing the purchase of own shares, the old Section 31. So they're basically the same, but I'm going to talk about some of the tweaks. I'm going to talk a little bit about the summary approval procedure. And that's the new whitewash procedure. That's Section 60, subsection 2, reproduced. We'll be talking about some of the differences between that and between the existing section. And then, I suppose, my own, a strange person that I am, thing that I greatly enjoy, which is the way in which the company's register is going to work, charges and priorities. And I'm going to be trying to incorporate there a couple of changes which came through at Janet stage. I'll draw them to your attention because they're going to be a little bit different to what you got in your written paper, because they hadn't happened when that paper was completed. So ultra vires has gone for the private company limited by shares. From a lender's point of view, that reduces the possibility of you suddenly discovering that you've lent to a company which didn't have the authority to borrow. That hasn't happened in a very long time. So to be honest, from a lender's point of view, everybody's still back worrying about Northern Bank and Quinn, but there really hasn't. And the Company Law Review Group did a very good, very thorough sort of study, and they're saying, look, that really there's no cases, that the problem hasn't arisen in practice, simply because people are careful, lenders are careful. One thing, again, a slight hobby horse of mine is obviously ultra vires is still there in the long grass for pre-commencement of this new legislation lending. And I suppose it is always worth being aware, and I think there is scope, should an issue ever arise, for the use of a restitutionary remedy. It's been approved in the UK, a couple of House of Lords and a Court of Appeal decision. Court of Appeal decision is sort of more directed. So that in other words, a lender who lent ultra vires had a restitutionary remedy. They were entitled to be paid back, notwithstanding that the loan was ultra vires. We may wish to talk further about that. To be honest, I don't really see it as rising to any huge extent. And I very much endorse Irene's comment about the sledgehammer and the peanut. Okay, so to talk a little bit about the old Section 60, financial assistance in the acquisition of own shares. And of course, from a lender's point of view, one is interested in this because, and I don't know if you can read the words on those boxing gloves, but the acquisition of shares in order to acquire property. So in other words, the borrowing to acquire property, acquiring a company in order to acquire the property which it owns, and suddenly finding yourself vulnerable under what is currently Section 60 and what will be Section 82. It's still prohibited. it's not lawful for a company to give financial assistance for the purpose of an acquisition made or to be made by any person of any shares in the company. The only big difference, and again from a lender's point of view, it's one that I would welcome, is you might remember it used to say it's not lawful for a company to give assistance for the purpose of or in connection with, which made that much, much bigger, and in connection with is gone, or will be gone. The beauty of that, I mean, William Johnson in his work talks about a case where several months after the acquisition, suddenly a lender found themselves in trouble because of, it was a New Zealand case, so not directly applicable here, but suddenly found themselves being caught because of the potential breadth of that in connection with. And you're going to see that the removal of in connection with kind of reinforced by some of the general exemptions to Section 82, and we're going to see those in a second. But the main point I wanted to draw to your attention there is that in connection with will be gone, so it's going to be tighter. So it's a tighter version of the old Section 60. Consequences are the same. Transactions voidable at the instance of the company against any person who had notice of the facts. And I put two little fellows there with notice because I wanted to draw your attention to an interesting little quirk which happened during the debate stage. Notice, was originally described as actual or imputed. I thought the little fellow would be the imputed. But imputed was removed eventually, was removed and has now been removed. So we're back at the Bank of Ireland in Rockfield. You may remember, you need to have actual, in order to be stuck with the difficulties here, you need to have actual notice of the facts which constituted the contravention of what was Section 60 and what will now be Section 82. So no change there. There was an attempted change, but that change is now gone. Okay, so the general exemptions. So like Section 60, Section 82 has a series of exemptions, circumstances in which the prohibition does not apply. There are general exemptions and there are specific exemptions. And again, remember, I'm coming at this primarily from a lending perspective, so I'm going to be concentrating on the issues of most relevance to lenders, or to the loan aspect of things. So in terms of the general exemptions, you'll see they're stated there where the company's where the company's principal purpose is in giving the assistance is not to give it for the purpose of acquisition. Or where the giving of the assistance for the acquisition is only an incidental part of some larger purpose of the company. The idea of this is to reinforce the removal of that in connection with. So in other words, to reinforce the notion that we really are talking here about assistance. We're not talking about ancillary kinds of deals. The assistance, in order for those general exemptions to apply, the assistance has to be given in good faith and in the interests of the company. The idea with all of this is to introduce more certainty. In connection with, in respect to Section 60, was seen as introducing an unacceptable level of uncertainty and creating a danger zone in that respect. I should point out, and I'm probably steering slightly into the academic here, but they don't identify incidental part and they don't identify principal purpose. So there's still a lot of room for manoeuvre there, and I think we will be looking to see what the judges, or how the judges will interpret those particular provisions. So I'm not sure that it's necessarily going to be all that more certain in the short term, at least. So they're your general exemptions, and they're set out in Section 82. In terms of specific exemptions, very, very similar to the current exemptions. There are a few differences at level of detail, and I just want to draw your attention to them. The one, of course, I'm most interested in relates to refinancing. And basically what this simply says is when the whitewash procedure has been used, so in other words, what will now be the summary approval procedure. When that step has been taken, that cleans or allows refinancing and refinancing of the refinancing. So in other words, you basically get you're all clear. And you don't have to be going back messing again about, well, messing is probably the wrong word. You don't have to continue thereafter. So that's, I suppose, one of the big ones. The other thing, I suppose, to draw to your attention in terms of, and many of you will be aware of this, in terms of representations and warranties, that exemption, which, as you know, applies to the making or giving by the company of representations or warranties to a person who purchases the shares, that now extends to affiliates of the company as well. So it's again broadened the representations and warranties, and the fees and charges exemption is also broadened. So you have some broadening, or in all instances a broadening of the exceptions. And we're going to come back in a moment, of course, to the whitewash procedure, to the summary approval procedure. Section 31, we've just seen mentioned, that's the loans to directors. With the loans to directors, we're working off, and for those of you who are reading this, we're working off page 4 of your handout. We're working off essentially the same, section 31 reproduced. It's reproduced in section 239. It works in pretty much the same way as the old section 31. Same definitions of loan, quasi-loan and credit transactions, so no big changes there, nothing dramatic there, change of number, but that's pretty much it. The exemptions largely the same. Some little changes at a level of detail. The de minimis exception, some of you will be familiar with the de minimis exception there in respect of the current section 31, which is of course where the amount is less than 10% of the company's assets. That remains as is, and as is currently the case, in the event that the company's assets reduce such that the de minimis exception no longer applies. That provision is reproduced, but you're getting a little bit more detail on how the matter is assessed. So to all intents and purposes, you're basically seeing section 31 being reproduced with a few tweaks at a level of detail. The big change, I suppose, in respect of the old section 31 is that the whitewash procedure, the current section 60 subsection 2, the summary approval procedure, applies equally to both acquisition of financing the acquisition of own shares and to loans or other dealings to directors. And I suppose I should, just in case anyone has forgotten or for a moment, we're of course not just talking about loans to directors there, we're talking about guarantees of loans to directors and provision of security in respect of loans to directors. So we're talking about something much bigger, but that's in no way different to the current provision. So as I said, the big thing is that we've got the summary approval procedure now applying the same essentially for financial assistance and for loans, etc. to directors. And that's a whitewash procedure. So, summary approval procedure. The idea of the summary approval procedure was that you'd have the same kind of procedure which would whitewash all sorts of things and allow you, so everybody would know exactly and it would be the same. Now actually it didn't quite work out like that because you have some bits, some sections which are in common to all whitewashed procedures, as it were, and you have some which are specific to specific procedures. What we're interested in for our purposes, which is again thinking about this from a lender and a loan relationship perspective, we're interested in section 202 and 203. So 203 is the specific targeted measure in terms of the way the summary approval procedure is set out. But just to be careful that you don't think that that summary approval procedure as set out in 203 applies to everywhere. Different designated activities, activities which can be permitted if they're whitewashed, will have different variations. But what we're interested in is the section 202-203. So you're working essentially with something very like the current whitewash procedure. So the model is largely the same. Again, the tweaks are primarily at a level of detail, and I just want to spend a few minutes though talking about them and drawing your attention to some of the changes. So you've got your same model, you've got your statutory declaration and your special resolution, and then you've got your transaction, and you've got the requirement to deliver the statutory declaration to the registrar. I've put in the time limits just to draw those to your attention. You note an expansion there, we're up to 30 days. The statutory declaration, that used to be 24, that's up to 30 days statutory declaration prior to the special resolution. There is more detail now in section 203 on what the statutory declaration has to contain. So you have it's the same kind of basic model, but there is a more detailed outline of what the statutory declaration has to contain. And obviously you have to have your director's declaration of solvency. So you're working off the same kind of a model. You have a little bit more detail on the factors which the directors can, or in fact don't have to take into account in making that that declaration of solvency. Directors, and this is set out in section 2032, and it's on your handout on page 6. Section 2032 says that declarants, in other words directors making a statutory declaration of solvency, shall not be required to assume either that the company will be called upon to pay monies on foot of a guarantee given, or that security given will be realised. And again, that's sort of fairly standard, but just given the statutory effect, in other words, with a clarity regarding the assumptions which have to be made. The special resolution, similar kind of model to the current model. Time limits, interesting there. There are two kinds of special resolution in terms of the summary approval procedure. I'm actually going to skip on and then I'm going to come back in a sec, because there is a possibility of a court application in respect of a special resolution in the context of the summary approval procedures, actually in relation to them all, not just my one that I'm interested in here, but in any of the summary approval procedures, unless 90% in nominal value of each class of issued shares has voted in favour of the special resolution. So in other words, if you have a group of people who have not, more than 10%, who have not voted in favour, there is a possibility of an application to court to overturn the special resolution. That possibility, so that the existence of that possibility, the application must be taken within 30 days. What that means is, and that's why I've got the two time frames up there, after your special resolution, if more than 90% agree, you're home dry, you've got your 12 months. If less than 90% agree, and there's a possibility of the court application, you have 30 days, you have to wait 30 days before you can do anything. Okay, so you've got that two different periods, depending on whether or not you've got the quite extreme majority of 90%. The final thing is, within 21 days of the transaction, the statutory declaration has to be delivered to the registrar for companies. Interestingly, there is a provision in the Act, and actually in the bill as initiated, the whole thing was invalidated if that delivery did not happen. So the whole thing went wallop if the delivery did not happen. You'll be interested to hear that the bill as passed by the Dáil, and this hasn't changed, allows for the possibility of court application if the statutory declaration isn't lodged in the company's office in time. So nonetheless, what you're working off is, if you don't get your statutory declaration in time, you have potential for invalidity, and you have to go to court to get that cleaned up. So be conscious, I think, of that.
Sorry, Mary, is that
Yeah.
both Section 60 and Section 31?
Yes, exactly. They're all the same now.
Yeah.
So everything I'm saying now is both.
Section 31.
Precisely.
Yeah.
Section 31 had its own different kind of approval procedure, and so the beauty of it now is it's all the same, which is certainly advantageous. So you only have to worry about one approval procedure. Although for other kinds of transactions requiring approval, there are some slight tweaks. But for Section 31 and Section 60, you're working at all times with the one summary approval procedure.
But you also have that fail-safe of being able to court to vote now.
Precisely.
Yeah.
Precisely. Yeah. So some tweaks there which could come and bite you, so you need to be aware of them, and you need to be aware of timelines in all of these situations. That's just the contents of the declaration, nothing very exciting there, just drawing that to your attention. And the possibility of the court application, which I've already spoken about, but worth being aware of that exists. And as you'll see there, that's a 90% in nominal value required before that possibility goes away. Okay, so I want to talk now for the last couple of minutes about changes in registration of charges and priorities, and as we see, changed priorities ahead there. So this is one that sounds sort of scarier than it is. There are differences coming down the road in terms of how we do priorities. I think they're pretty sensible, but I'll take you through them and see what you think. Okay, so we've got the requirement to register. So we're now working off what is Section 99 of our current legislation, primarily Section 99 on. You have, as we have under the current legislation, a requirement to register, and that will apply only to charges created after the commencement. I'll talk a little more about transition later on, but the big thing to remember is up until the commencement, the old law still applies. So, and in respect of charges created prior to commencement, should you ever be trying to enforce them post-commencement of the new legislation, you're still going to be working with your old law. Was it properly registered under Section 99? Did it fit within Section 99 too? Was it a registrable charge? So that's not all going away just yet. So you will need to continue, or you will need as a lender or whatever, in assessing or evaluating a situation, to be aware of the fact that it's only after commencement that this new measure comes in. So you still have to register. You have to register all charges. Now this is different. The legislation, or the bill, and it's very hard to see this changing. This has stayed very, very static. You have to register all charges. Now the fund comes, so unlike the current measure where you have to register everything outlined in Section 99(2), we now have an encompassing definition. You register all charges with some exceptions. So I'll talk about those exceptions in a minute. But we're aiming at a more encompassing, all charges and mortgages created after the commencement. You have to register judgment mortgages. They're included, so that's a difference. And any property acquired by the company subject to an existing charge has to be registered. If you don't register, just as in the current situation, you have your sanction of invalidity. And again, from the lender's perspective, it's exactly the same as under the current situation. The charge is void against the liquidator and any creditor of the company, but the monies secured by the charge remain payable by the company and become payable once the charge becomes void, which of course happens, because we're still working with the 21-day period, which happens 21 days after the charge was created. So in other words, if the charge is not registered within the 21 days, all those monies become immediately repayable by the company. But that's not a change. There's no change there as such. Oddly enough, it remains the company's duty to register. They've left that in. because obviously it'd be a pretty foolish lender if you were relying on the company to register the charge. They've left it in. They've removed the criminal sanction for the company failing to register. I thought they could have gotten rid of it, but they didn't. So, in other words, we're looking at something which is pretty much the same. Different section numbers, but the same kind of model, except for this issue of all charges are registrable. Rather than a list of charges which are registrable, all charges are registrable except. So, you have an inclusive definition of the charge. It's a mortgage or charge in an agreement, written or oral, that is created over an interest in any property or assets or undertaking of the company. So it's a grand big definition there. And here are your exemptions. Charges over cash, money credited to an account of a financial institution, so charges over bank accounts, or other deposits, shares, bonds or debt instruments. So these do not have to be registered. Usage of money market instruments or claims and rights in respect of any of these. Now the purpose of this, you might be wondering, depending on how used to dealing with financial security over financial collateral you are. The purpose of this is to enable or to bring some kind of clarity to what had been quite a messy situation. Does that sound a bit better? Yeah. Okay, some kind of clarity on what has been quite a messy situation in relation to the Financial Collateral Directive. Now, the Financial Collateral Directive, as again those of you working with financial collateral will know, was transposed into Irish law, and, well, the most recent version was transposed into Irish law in 2010. And the thing about the Financial Collateral Directive is if provided you fit within the Financial Collateral Directive, you don't have to take steps to perfect your security interest. So in other words, you don't have to register. The problem is that there's been a huge amount of uncertainty regarding the scope of the Financial Collateral Directive. So everybody was saying, well, is this in or out? And obviously, as you all know, if you get it wrong, you're really going to suffer because if you fail to register. So what everybody did and does is they register. If involved with financial collateral, even though technically you very likely don't have to register, naturally we're all cautious people, people tend to register. So the effect, the value of the Financial Collateral Directive was really being missed. So from that perspective, the company law review group were very concerned about that. So as a result, they've outlined a set of exemptions and have said clearly, you do not have to register these. These do not have to be registered. The idea is this is a match-up. So in other words, the Financial Collateral Directive takes over in respect of these. Again, being slightly academic here, I would suggest that you don't have a complete match-up. And it's worth being conscious of that you don't have a complete match-up. There are still some financial collateral which are covered by the directive which aren't covered by these exemptions. And personally, I would just register them. Just pretend it isn't happening. You're safe with these, and then take the cautious approach with everything else. But that's just again a personal view. They didn't take the option, and some people thought they should, of introducing registration for quasi-security, because as you all know, particularly any of you working in the insolvency area will know leasing arrangements, hire purchase arrangements, retention of title, all of these bubble along under the surface and are of course not registered anywhere. That's not changing. This is what I mean when I say it's not particularly radical. The company law review group, in my view, made a very good case that we were doing okay with quasi-security operating unregistered and everything else registered. But it does mean that just as the register can't really be entirely relied upon now, in a lot of respects, it won't be any different after the bill comes into being. Okay, so how am I doing time? Just to draw your attention to the fact that we now have 2 registration procedures, and some people are a bit concerned about this. As we know, in the old days now, for example, you lodge your particulars, and that's that. We're still going to have that. We've now got a potential for a two-stage registration procedure. And that procedure means that you lodge your particulars, and then at that stage the charge isn't created. So you lodge the particulars of the charge you're planning to create. And then you come back 21 days, you've got 21 days to do this, and you come back and you say, we've done it now, we've created the charge. As you'll see there, registration is then backdated to the day on which you lodged the particulars. Now you may be saying, well, why did they do that? Are you saying that, or do you all? Yeah, the reason they did that was it's kind of part of a notion, which is that if you're negotiating, it fits within a notion of notice filing. So in other words, you're negotiating with a borrower and you want to protect your interests. You run off and you lodge your particulars and then you continue negotiating. So it buys you, the idea is it buys you that kind of a 21-day period to keep negotiating, and then either you agree or you don't agree. If you agree, brilliant, it gets backdated. If you don't agree, the registrar is incidentally required to remove it. You don't have to do anything, the registrar is required to remove it. It would work an awful lot better, in my view, if you really had notice filing. But in other words, if all you had to do was put a marker down. But what you actually have to do is lodge the particulars, do the full job of work, and then 21 days later say, okay, we're good to go, or nothing. So that's the idea. That's the idea between around the one-stage and the two-stage procedure. It'd be really interesting piece of work to be done as to how many people use that two-stage procedure. It'd be very, very interesting to see whether it actually is. Okay, changes to the register itself. Big changes you're going to see, but they're not big actually, they're fairly small. Main changes you're going to see is the amount of the loan is going to be removed. And the Company Law Review Group explained this, and they said, look, everybody does an all sum secured anyhow, so it's pointless, so that's gone. The date of creation, and then also whether it's a one-stage or a two-stage, that will be recorded on the register. But the register isn't going to look that different except for the one-stage, two-stage. Okay. Priorities are going to change a little bit. I think for the better, but see what you think. You are probably all familiar with the 21-day blind spot. So in other words, we have this very peculiar mechanism of doing priorities at the moment. So it's the first charge created, provided that the charge is registered within 21 days. And so you've got your blind spot. Because you could, somebody could come along, create a later charge, and suddenly find a charge popping up. We're on to a much more straightforward kind of an idea, which is it's the first charge received by the registrar. So in other words, I would suggest it should have said first charge registered. In fact, I did, but nobody listened to me. In other words, I would have thought the register should be the determinant factor there, but actually they've stuck with what they had. I don't know if it's ever going to make a difference in practice, but nonetheless, that's the position. So it's first received. So in other words, we're going to get away from that blind spot, or that concern about that blind spot. That's subject to other enactments, and I want to talk very briefly about that for a second. It's also subject to priority arrangements. So if you make a priority arrangement that you're going to, arrange priorities as a lender among yourselves in whatever way you want it, they're fine. They're not going to be affected. This is the default position in the event that there isn't a priority arrangement. Okay. The bill is supposed to be very user-friendly. I think it's funny. But this section, which is section 412, which is one of the channeled amendments, which I'm starting to come to terms with, I don't think it's particularly user-friendly, just in terms of the language which is used. I'm going to tell you what the section is trying to do. So this is different to anything which I have written on the paper, because this is something which I've just become aware of. The picture of Sean Sherlock is because he was the person who brought the amendment to the Shannon for no other reason. I don't think he was on a head stagger of his own. I think it was coming from the department. What the department want to do is to introduce a measure, and this is what the new section 412 is doing. Okay, so in other words, not the one in the bill as passed by the Dáil, but the one in the Shannon amendment, and I'm hoping they'll tidy it up a little bit. What the bill is trying to do is to make provision for security over future advances. So any of you who are familiar with working with the Land and Conveyancing Law Reform Act or the Registration of Title Act will know that you can have a mortgage or a charge which covers future advances as well. And that basically works unless the first chargee is served notice by a new chargee. So in other words, it works, covers future advances, but basically the way you kill it off is by serving notice on the specific chargee. That'd be something you'd be all fairly familiar with. Well, the company's legislation as was passed by the Dáil, didn't have that provision. It simply did priorities on the basis of registration and didn't include anything about what happens if you've got a security interest which is covering, which is very typical, which is covering future advances over a property which isn't land. So if it's land, it's covered by the Land and Conveyancing Law Reform Act or the Registration of Title Act. But what about something else? The idea of section 412 is to ensure that the same kind of measure applies. So in other words, that you can create security over future advances which works effectively unless a second chargee serves notice on the first chargee, and that basically will stop them in their tracks. I'm not even going to show you, because you would be horrified, the many sections spent on trying to do that. I think it can be done more neatly than it has been. And we may see some changes, but that's the principle that they're trying to get at. Nearly there now, and nearly there in terms of timing. The 21-day limit remains. A lot of people have said, well, why have a limit at all? If you do priority in terms of time of registration, or time of receipt by the registrar, if you do priority on that basis, well, you don't really need a 21-day limit. And a number of people have argued that, but they've kept it. So the 21-day limit is still there. And you still have all the provisions whereby you can go to court if you don't get there in time. And I could kind of talk a little bit about why I actually think it's a good idea to keep the 21-day limit. But anyway, they've done it, but you still can make your application to court. Okay, judgment mortgages, they've always been very unsatisfactory in a company position. And there's a nice bit of tidying up done here. The main point being that the judgment creditor, who after all is the person who's going to want to register the judgment mortgage, can now effect registration. It was a very higgledy-piggledy, or again, many of you are working with it, very higgledy-piggledy position under the current legislation, so it's tidier. Registration has to happen by the judgment creditor within 21 days of his receipt of the notification from the Property Registration Authority of the creation of the judgment mortgage. Interestingly, in the bill as passed by the Dáil, there was a provision on priority in respect of judgment mortgages. They basically slotted into the priority system that we've just seen, the first registered. That's gone now. And the reason that's gone, so there's nothing on priority of judgment mortgages in the company's legislation. The reason it's gone is because there was concerns in fairness, legitimate concerns, that you would have a conflict. You would have two sets of priority rules. You'd have your land and conveyancing rules, and you'd have your company rules, and they don't completely talk to each other. So from that perspective, it's gone. Priority of judgment mortgages is determined in accordance with the Land and Conveyancing Law Reform Act. Extraneous material. This is a change as well. We really are nearly there. My apologies. This is a change as well. I imagine, or do many of you try to register negative pledges? Well, as you know, lots of people try to register negative pledges, and the registrar generally sends them back. From now on, there will be a specific statement that certain material, what's described as extraneous material, shall not, I've bolded it, shall not be entered in the register. And the fact that the registrar has received them, so you send them in anyhow, will have no effect. Now, up until the Shannon, that was just about negative pledges. So in other words, you can't kind of try to get a negative pledge. But the Shannon has changed it, and now you have three definition of extraneous material, which encompasses three different kinds of interests. Any particulars of a negative pledge, any events that crystallise a floating charge, and that's the one, of course, one would naturally be trying to, and then any restrictions on the use of any charged asset. No point in sending them in because the registrar cannot receive them, and the fact that he's received them, or the office has received them, has no legal effect. That's the intention on that. Certificate remains as conclusive evidence. Just one little tweak there, not a particularly big one. If the particulars of the charge omit the required particulars, so the charge deals with more than one property, if they omit the required particulars in respect of one of the properties, the certificate does not extend to the omitted, the properties to which the omission occurs. It's a small little difference, but it's a useful little one. Okay, very, very briefly, satisfaction has always been unsatisfactory, and the potential there for a rogue borrower basically to lodge satisfaction inappropriately. What they've actually done, and again there are various ways they could have, and this brings us back a little bit to Suzanne's argument earlier, they've introduced criminal liability there. So you've got criminal liability if somebody signs and did not honestly believe the statement to be true, signing a statement regarding satisfaction. More significantly, I would think, the person who signed a declaration of satisfaction, we can talk more about that in a second, is potentially liable for the entire debts of the company, personally potentially liable without limitation. So the idea there is to just get them. And then in terms of transition, and this is obviously a bit down the road, all charges which are created before and not registered before. So this is a big issue because obviously people will continue creating charges. Created before and not registered before the date of commencement, the old rules will continue to apply. So in other words, you've kind of got a 21-day window after commencement when you're still working with the old rules and the old priority rules. And I'm sure someone could do something very interesting with that if they were bad-minded enough, but there you go. So that's all I wanted to say. Apologies if I went on a little bit long there.